It should be noted, I think, right from the outset, that this evening's presentations and discussions are being held in an environment of what I call best endeavours and good faith, in that the new Act is totally untested and untried. There are no legal precedent or case law to rely on. Rather, it is our best interpretation given our knowledge and expectations. This alone should make for some very interesting discussions at panel when we get to the Q&A panel. Allow me to introduce the two speakers and invite them to the stage. Our first speaker is Chris Duggan, one of our joint managing directors. Chris is a director of the Strata Community Association, which is the peak industry body for body corporate and community title management in Australia. During his tenure, Chris has served in the role of Senior Vice President of SCA New South Wales. Chris is a presenter at numerous industry events and conventions. The second speaker will be Melissa Truscott. Melissa is Bright&Duggan's Group COO. Melissa is also on the board of SCA New South Wales. Among her many activities within the strata industry, Mel is a regular presenter for SCA and for the City of Sydney in its Strata 101 program, with particular focus on lot owner education and best practice management. May I please invite Chris and Mel to the stage.
Thanks, John.
Thanks, JD.
Thank you, John, and welcome on behalf of Bright&Duggan. For those that didn't miss, I'm Chris Duggan. We're going to go through on a bit of an overview of how we're going to handle today. So a short history of the changes to the strata management laws in New South Wales, followed by the key dates and how they impact on you and when they become effective. Melissa's going to take you through the terminology changes, which will impact you, and it's going to take a lot of upskilling and changing in the way we refer to ourselves. So I won't second guess a few of those, but they change a lot of the colloquialism that we know about strata. Doesn't necessarily change the way strata operates, but it's going to tweak the way we refer to ourselves. Then we're going to go through what we believe the key changes are and how they impact on you. Bear in mind, we've had to cherry pick the major changes. There may be some things that are relevant to you, there may be some things that aren't. What we'd ask is that you have any questions specifically that we don't touch on, or things that you want us to develop more or unpack, please ask our expert panel, which is Chambers Russell Lawyers and ourselves afterwards, or feel free to ask our staff and any of the staff of the lawyers outside in the foyer afterwards. Finally, we'll go through Bright&Duggan's implementation and what we're doing to assist you. We're very much on this journey as much as you are. So our team is trying to upskill ourselves, as are you. We intend to give yourselves and ourselves the best chance and the best environment to do so. We'll go through a short best laid plan scenario, followed by the Q&A panel. So where it all began. So for those, I'm going to go very quickly through a brief history. The strata law changes in New South Wales haven't really changed since 1996, when the previous strata laws were introduced. In 2011, Clover Moore presented a private members bill via the City of Sydney Council, and that started to percolate the discussion around strata laws. There'd been a lot of discussion about change, but this seemed to crystallise a lot of the media into making sure those changes occurred. 2012, fair trading commenced what is known now as one of the most, consultative processes for legislation change ever in New South Wales, and they received thousands of responses, as well as held many, many meetings and life cycles. Melissa and I have been involved in many of those meetings since 2012 in our capacity as Directors of Strata Community Australia, and we've seen a lot of the iterative changes that have occurred over that period of time, which have led today to what is now a very collaborative arrangement amongst all those groups and many others to come up with the current Act and regulations. Key dates to note, obviously, that you will need to be effective from immediately is Strata Schemes Management Act, the Regulation and the Development Act all become effective as at 30th of November. The one condition to that is the Community Land Management Act has been left off completely. So that doesn't necessarily impact on many of you here, but those who live in a community will know that that piece of legislation, which now hasn't been touched on coming up to 3 decades, was supposed to be brought along this journey, and the changes were supposed to be reflected through into what we see being implemented today. Hasn't happened. Likelihood of that happening in the near future is not likely in the very short term. Just reiterating the little comment down below there that John has touched on, we're interpreting this Act as much as anyone else. We've got legal advice around how that interpretation occurs, but that advice is not in the context of any precedent that exists in the marketplace. So where we do make assumptions, some of them are factual and very easy to interpret, some of them are going to be our view of the world backed up by Chambers Russell. The building bond scheme, which is for new strata plans, is effective from mid-next year. So we're not going to touch on that too much because the relevance for existing schemes is limited, but it does introduce what we think are very strong measures to deal with the building defects issue that is becoming systemic throughout buildings in New South Wales. And finally, the other key date, 13th of March 2018, this has been introduced some years back, which is the mandatory requirement for all windows to have window safety devices fitted. So you would have seen on your agendas more recently over the past couple of years for this to be dealt with. We need to make sure that we keep ahead of that date because the closer you get to that date, the more urgency around compliance will occur.
Thanks, Chris. For those up the back, if I'm not speaking loud enough, please just tell me to turn up the volume. So I just wanted to touch first of all on some of the things that will be particularly relevant to yourselves and the easiest things to take away from this probable presentation, and that's the terminology. So as with many industries, we have a hell of a lot of acronyms in the strata industry, and some of them are up there. We've got BMCs, EGMs, AGMs, ECMs, ECs, the list goes on. So in the government's infinite wisdom, they wanted to change some of those. So I'm going to take you through a few of the basics. The main one that will affect all of you here is the Strata Committee, no longer the Executive Committee. And quite interestingly, one of the reasons why Fair Trading told us that they changed the term Executive Committee to Strata Committee is primarily because the term executive made people assume a theory of power around their role. So this is one of the key reasons why they changed it to Strata Committee, so it would reflect a more consultative committee. Then we've got the Capital Works Fund, previously known as the Sinking Fund. A lot of people that aren't exposed to Strata when they first join Strata, they don't really have an understanding of what a sinking fund is. So Capital Works is more in line with standard financial terms. And then we have building managers. So some of you may have caretakers currently within your buildings. These are now incorporated under the Act under the term building manager, as is in-house residential managers and the like. The key difference here is that under the previous Act, the caretaker, the way that was defined was that they had an exclusive use area of the common property, and that no longer applies under this new Act. Finally, exclusive use rights bylaws have changed, and they are now known as common property rights bylaws. So a slight nuance in that term. As you may know, exclusive use bylaws apply to things like lot owners having specific rights to perhaps common area roof space or rooftop gardens. So this is where those bylaws apply. So now we're going to hit through the main key changes, and these are likely the things that will interest you the most moving forward in this presentation. So the Strata Committee. I'm just going to touch mainly on the changes, so we won't delve too much into what's remaining. So interestingly, they have excluded building managers, real estate agents, undisclosed connection to original owner participants, non-financial lot owners from nominating for the Strata Committee. Very interestingly, I picked up today actually, was that co-owners may no longer serve simultaneously on the committee. The only way a co-owner, both co-owners can serve is if they have multiple lots within the property. One that's got a lot of media attention is the tenant representative that may be eligible to the committee, and we'll touch on that in more detail a little bit later. Interesting one here is the liability has transferred to the owner's corporation when a committee member makes a decision in good faith.
Just touching on that, that's probably one of the more interesting questions that I'd like to direct to our lawyer friends when they come up. Currently, obviously, the liability that exists as the executive committee member is unlimited. So all the decisions you make, you can be held accountable for. This introduction for us is one of the more interesting, phrases. The words acting in good faith, how that's going to be tested out, what that implies with regard to liability, and how that then passes on to the owner's corporation. So for those people on committees here, I think that's probably one thing of interest, and I would ask our lawyer friends to actually unpack that a little bit when we come to that in the Q&A.
So you would have also heard a lot about approval of voting other than in person, and again we'll touch on that in more detail further down the presentation. Any pecuniary interest that a member of the committee has must be disclosed to the committee. And this was not previously detailed in the existing legislation. So what will happen now is that they will be excluded from voting on any matter that's in relation to that interest. And if the committee so chooses by a resolution, they may not even be allowed in attendance at the meeting when it's discussed prior to the voting taking place. There's a slight change now to vacancies. You used to have a responsibility on yourselves to fill a vacancy. There's a nuance here with regards to members versus office bearers. So there's no formal obligation to fill a strata committee member. We're all still learning the terms. But there is an obligation to fill the role of an office bearer. One thing you should take in note, especially, is if you have a committee and there are resignations, that original committee number still applies to calculating quorum. So it may be, in some situations, you will really need to try and fill those vacancies so you get quorum for your meetings. Act has also now changed so that for a large scheme, there's a minimum of 3 members. We would always recommend at Bright&Duggan that you consider having odd numbers. Always makes it easier when there's a little bit of conjecture. So that's something to keep in mind with the new Act.
And just to clarify that, a large scheme is defined as more than 100 lots. So it impacts on some of you here, and those 3 people, we expect you should be able to get those in attendance at meetings. But touching on some of the new quorum requirements, this is going to be interesting moving forward and actually how those meetings play out. So strata managing agents and building managers, there was quite a bit of introduction of new legislation, particularly about our contracts. So notwithstanding the fact that we have to be licensed under the Property Stock and Business Agents Act, our agency agreements have come under a lot more robustness around how the actual appointment is made, what tenure there is, and ultimately how those renewals occur. So anyone connected to the original developer cannot be appointed for a minimum of 10 years. Now, there was one particular developer that actually had a strata manager attached to them, I think brought this on. We don't expect it to be a bit, too much of a problem, but it will have impact on some businesses in terms of the way their business model is structured. For minimum term of 12 months to 3 years. So the 12 months applies for brand new buildings after the first AGM. However, there is a new introduction of a limitation of 3 years for any other strata management agency contract. They're all effective from the 30th of November, and they have amended the auto rollover clause. So we will be communicating this with you, but currently, if an agreement expired 2 or 3 years ago, the delegations continue, and they've needed to continue because we've had to do certain things for you on your behalf to act as your agent. However, after the 30th of November and a 6-month period thereafter, which is a grace period, those automatic rollovers will not occur. There is a mechanism that can be used for an extension by the Strata Committee. However, we need to notify that committee 1 month prior to, and the Strata Committee, the old executive, can then extend it for 3 months, and you can do that on a rolling basis until you come to your your next AGM. The reason we're putting this out there is we're going to likely come to you at a point in time and say we need to actually put in place agreements if they have expired, or need to put in place new agreements at a point in time to make sure those delegations don't cease. The impact of delegations ceasing is very significant. It means that we can't operate your trust accounts, we can't issue levy notices on your behalf, we can't accept any of your instructions. So it's very important that we meet those deadlines. We'll actually make sure that we tell you when they're going to occur and how those renewals are likely to occur, but just expect that obviously during the transition period we're going to be having the conversation around agency agreements. The acceptance of gifts or benefits has now been inserted into the Act, and they've put a dollar figure of $60 as the minimum amount of a gift that a strata managing agent can receive now from any contractor or supplier to a strata managing agent, and that needs to be also recorded on an interest register. That excludes any commissions which are disclosed in agency agreements, and there's also a little bit more around the way commissions work, and also training that may be provided via suppliers and the like in terms of how the legislation is implemented or any other things that impact us on a daily basis. Building management agreements, due to some of those terminology changes that Melissa referred to, are now being brought into the Act, which means they're brought into the remit of the tribunal in terms of the way they assess those agreements. So for those with caretakers or building managers, they now have some of the limitations that exist around the 10-year time frame for contract tenure, and also they bring the terms of that particular agreement under NCAT's authority.
Thank you, my favourite. Tenants. I know a lot of you are quite scared about the concept of tenants and power within the owners' corporation, so I'm here to assure you. So a tenant representative is to be elected, but it is subject to a 50% threshold within the strata roll. So many of you may not know, but under the Act, both past and present and future, the owner or their appointed managing agent is responsible to notify the secretary or the strata managing agent of a lease on the property. Many of our esteemed real estate colleagues don't always provide us that information, so we actually don't have it on our strata roll. In all honesty, there is a very limited number of Bright&Duggan buildings that would meet this requirement. Whilst you may live in a building that you know to be definitely more than 50% tenanted, it is very unlikely that we have all their details on the roll. However, for those small amount of clients that do, the tenant representative is a notice of a tenant representative meeting must be issued to all registered tenants on the strata roll. A notice is to be, and this is something we lobbied at quite strongly when we were with Strata Community Australia with fair trading. A notice is to be issued by written notice or on the notice board. So in the original draft of this, fair trading thought it was completely reasonable for us to send hard copy notices to tenants of any annual general meeting or tenant representative meeting. Our first question to them was, why should the owners' corporation pay for that? And they obviously didn't realise that the owner corporation does pay for that. So we now have it reduced so that it may only be placed on the notice board if the building has one, and it must be placed on all notice boards. The notice must be issued a minimum of 14 days prior to the annual general meeting taking place, and the meeting must take place a minimum of 7 days prior to the annual general meeting. There's quite a lot of procedure around that we need to implement and get our heads around from an operational perspective. The quorum for the meeting is 1. And interestingly, any subsequent vacancy during that year or until the next annual general meeting or tenant representative meeting, if there is a vacancy, and we all know tenants come and go quite often, then that vacancy must be filled and you need to go through the entire process all over again. It's not a matter of the executive committee just appointing a tenant that they are familiar with.
Melissa, it remains to be seen whether that 14-day notice period, if you do have a tenant representative or have more than 50% registered on the roll, will impact on the meeting process around the legality of calling those meetings. Those who have had an issue around the time frame for meetings being called in the past and someone challenging that at a tribunal now needs to be mindful of the potential extra days added in by the notification of tenant reps and whether that would likely impact on the validity of that meeting. Again, without precedent, we have to assume that the way the Act is interpreted is it does. However, I could see that one being played out very quickly in the tribunals and getting some certainty around that.
Thanks, Chris. Okay, strata committee meetings, again, something quite relevant to the majority of you in the room. So this is where we'll go down into a little bit more detail. Both strata committee meetings and other general meetings of the owners' corporation now allow under the legislation for meetings and voting to take place in many different circumstances. So they're talking about teleconference, video conference, email, or any other electronic means, which could be open to whatever is out there in the future. I'm sure that's what they've planned for. There's also this option of pre-meeting electronic voting via email or possibly a voting website. We've had some discussion about this amongst our industry peers, and whilst a lot of us are informally allowing some of these procedures to take place at the moment through teleconferencing on mobiles or Skype, and we have been utilising them, to make every single one of these options available to every single meeting is certainly not practicable. And depending on the culture of a particular building, it may not be realistic either. The other interesting thing about the legislation, it doesn't automatically provide these solutions to you as a member of an owners' corporation. The owners' corporation must resolve to opt in to one or all of these solutions. And you can really only opt in to the solutions that your service provider has available. So we'll probably spend the first few months trialling with some of our buildings which methods work more appropriately, which methods work well together, and come up with a recommended solution for all of our clients. One that I was very pleased to see is the notice of the meeting must include a detailed agenda. And the reason for this is a lot of notices of agenda go out for strata committee meetings that have not a lot of substance. And because of that, there's not a lot of transparency for the other members of the owners corporation. So they're not aware of whether they should attend the meeting or not, even as an audience member. Of course, we have the tenant representative, if it's appropriate, in attendance. They don't have an entitlement to vote at your strata committee meetings. They may not assume a position of office bearer. And finally, they don't contribute to the quorum requirements.
Thanks, Mel. Likewise, for annual general meetings, the methods of attendance likewise need to be resolved by the owners corporation. So I imagine it would replicate that of the strata committee. The one point I would make here is that I think enabling people, particularly lot owners outside of the strata committee, to attend may not mean that they're going to participate in the meeting. If you can't attend one meeting once a year for your AGM to discuss important matters, it's unlikely you're going to log in via Skype at a point in time that's inconvenient to you in the future. So I wouldn't necessarily bend all of your practices around making sure you get these people to attend. It may well be just more convenient for those people like yourselves who are more engaged, be able to attend when it's more convenient for yourself. So the AGM must be held once in a financial year. At the moment, there's a peculiar wording around being held 11 to 13 months after the registration of the plan, which occurs then at a time that's not convenient to your financial year. It's all over the shop. This time it says it must be held once each financial year. There's going to be a transition period of how that actually plays out, but you'll be able to much more meaningfully budget and plan that meeting around the end of your financial year, when audit reports are made and when you'd like to hold that meeting, without being in potential breach around the actual time frame that does exist in the Act. Calls for the strata nomination for the committee must be made 7 days prior, or they can be made rather 7 days prior, and that'll be included on the agenda pack itself. So you will actually get an opportunity to put yourself forward for the committee in writing prior to, and obviously that would get circulated at the meeting for those there around whether you'd like to put a bio or anything relevant to yourself around your nomination. Interestingly, we also need to accept oral nominations at the meeting itself. So what that means is if you choose to put in writing your nomination prior to the meeting and then not attend that meeting, or if you choose to pre-poll, if that's an option available to you, someone may nominate from the floor and then you've got no opportunity to vote on that. So that's another interesting timing element that needs to be played out. Likewise, though I think this exists at present, those nominated must accept in writing or orally at the meeting. That exists at the moment in the current Act. And non-financial owners may nominate for others, but not for themselves. So it's trying to bring back, I guess, a little bit more accountability around the payment of levies. Some standard motions that have been introduced. Again, building defect motions apply only to new schemes, but it's important to note those in a relatively new scheme, the government has made some progressive steps around the way that warranties are to be considered. So if you have any statutory warranty period applying to your building, there needs to be a motion on every agenda until such time as that warranty period expires. So it's going to promote the discussion, it's going to make sure things are not lost, and it's going to certainly ensure far more accountability for builders and developers around that. Again, builder or developer or connected person must abstain from votes around how those defects are handled. Motion to consider commissions received and future commissions. So this is touching back before around the disclosures that are required for strata managing agents around insurance commissions. So we must disclose to you, as we already do in our agency agreement and at the time of renewal, but we now must put it on the AGM agenda, how much we received last year in commissions and how much we estimate to receive in the future year in commissions. Now, for those of you who are aware, our agency agreements are predicated on the fact that we typically do receive a commission, and therefore our agency fee or our management agreement fee is based on that. So there may be options introduced in the new agency agreement to elect to opt out of that for one fee or accept it for another. So we're going through that at the industry level with SCA about how to present that in the most transparent manner for owners so they can actually pick with full transparency and accountability which option suits them best. And the consideration of overdue contributions. So levies in arrears, the option will now be that we can formally enter into payment plans via a general meeting resolution for a period of up to 12 months. So we already provided as a business a rather flexible payment process because we're aware that people do suffer financial duress from time to time, and we always tried to work within the parameters of the Act to make sure that liquidity could be upheld as well as being fair to owners in arrears. This seeks to formalise it via a general meeting resolution. Some people may not be overly comfortable with having their financial matters discussed and then agreed upon by an owners corporation general meeting, but that's the way that the tribunal has sought to put that forward. This doesn't stop, I think, and I'd be happy for Daniel and Scott to talk a bit further, this doesn't stop the tribunal putting in place a payment plan which is similar to what happens now, which may well be in fact very similar to what an owners corporation may have been obliged to accept in the first place.
Thank you, Chris. I just thought I should flag actually, I just noticed down the front here, Diane is my sort of person. She's been diligently taking notes. We will have a copy of this up on our website in the next few days. So just some general consistency for general meetings of the Owners Corporation. So with regards to quorum, this is a significant change for us. The chairperson may declare the meeting commenced after 30 minutes, regardless of 25% of lot owners in attendance. So that's a big change. Alternatively, they do have the discretion to adjourn the meeting.
I see this as one of the more progressive changes. Those who have ever attended an adjourned meeting where you're one person short of a quorum and then need to return the following week, and typically your proxies, if you provided them, can't be provided. So it was very, very time consuming and actually prohibited those people who attended the first meeting and penalised them. So this is a good introduction of a new way of dealing with that, but it does introduce some elements of risk, I think, and we'll also talk to our lawyers about if a chairperson or the strata managing agent declares a quorum after that 30 minutes and something controversial was passed at that point in time, does that carry any liability? Noting the best endeavours or due care responsibility that's now been inserted. Something to think about, because again, I can see this as being an area where someone would take issue with someone moving ahead with that meeting and trying to, in their opinion, ram through an agenda. So again, this is the one that we expect to see some early precedent on.
So another massive change for us as well is with regards to proxies, and some of you will be very happy about this. I'm sure there will be some people that aren't very happy about it. And this is to eliminate proxy farming. So what the government has in place is there is now a limit of one proxy per person if the building has less than 20 lots. And in excess of that, there is a limit of 5% of the total number of lots allowable to any individual member.
This one, again, is going to present some potential problems from an administrative perspective. So if you're a chairperson or if the strata manager is acting in their delegated chair capacity, in what order do they receive those proxies? If there's a limit of one, is it the first proxy that is given based on date? Is it the proxy that is more attuned to the way you'd like to vote? Is it which with the highest unit entitlement? Likewise with the 5%. So again, these are some of the issues that we see from a practical perspective are certainly going to cause some conjecture. And again, we're going to have these played out through the tribunals in very quick time, because this will bring up some issues very quickly about how those proxies are used and the intent with which the person is using them. Because that can be manipulated quite easily around unit entitlement and also about the way that particular proxy is directed to vote.
The deliverable for financial statements has changed as well at the provision of a notice of general meeting. We're now required to provide any notice of agenda with a one-page summary that's been prescribed by the government. That said, even though the government has restricted some of these deliverables, we'll continue to do the best practice options that we've been offering to our existing clients. So, for example, our status reports that we currently send to treasurers will continue to distribute those. There's also all of the financials available 24/7 on the website, so we won't prevent that sort of accessibility being made available in future. Tenants, as I said, must receive a copy of the notice of agenda or copy of the notice or a copy placed on the notice board. So not only regarding the tenants' representative meeting, but also every AGM moving forward or general meeting moving forward. They're also now entitled to attend any of those meetings. However, they don't have any voting rights. What hasn't changed, they will still have voting rights if they have a proxy delegated to them by the lot owner. They may not speak at the meeting unless there's a resolution of the Owners Corporation at that time. Interestingly, Owners Corporation can decide at the beginning of every meeting or on the fly, so to speak, or they can make a standing resolution with regards to that. They also may be resolved that they should be removed from the meeting when the Owners Corporation discuss financial matters, and that's at the Owners Corporation's discretion. And lastly, secret ballots are permissible in certain circumstances. The Strata Committee can call a secret ballot at any given time, and more than 25% of lot owners can seek that same a secret ballot motion at any given time.
Interestingly, we've been discussing the event of a poll being called on a secret ballot and how that is to be recorded, because a poll obviously is in accordance with unit entitlement. So someone will need to provide a document to the returning officer with how much their particular vote has with regard to unit entitlement, whether they're financial. So you can see that the well-intentioned legislation is going to hit very quickly with the practical limitations of how that works. There will be solutions that are put forward, but we suggest there's going to be some teething issues around how these things operate. Repairs and maintenance. This is probably one of, if not the more significant introductions in the new Act. So for those familiar with the current obligation, which is the Section 62 statutory obligation, which you must repair and maintain the common property, this has been turned somewhat on its head in that the Owners Corporation may defer that duty if action has been taken against an owner or responsible party in relation to the common property. What does that mean? So interestingly, a developer would be a party particularly who is responsible for certain defects, as long as there is no safety risk. And they use the word safety risk, I think, in reference to the structure, not to the people or inhabitants of the building. So if you have a defects claim on foot and you are pursuing a developer as they're responsible, you may well actually have an exemption from compliance with the Act. Now that may be good for some buildings in terms of deferring works, but someone is obviously living with those defects on a daily basis, and it's turned on its head the current obligation to strictly repair and maintain. That one I see being played out in a very interesting way, because it may well be used whereby a tenant has damaged a door, or a tenant has damaged, or an owner-occupier has damaged part of the common property, and you defer that particular repair because you're pursuing that person. Which, if you read the next clause down, is direct conflict with the fact that an owner can claim damages from the Owners Corporation for failure to repair common property. So you can see here where automatically you've got some conflicting motions and how they're going to play out. I've seen particular scenarios where both of them would be used very opportunistically by certain parties seeking to make certain agendas be put forward. There's a statute of limitation on the claim for damages against the Owners Corporation of 2 years. I know Daniel's got some particular points around the top one, around the deferring of the common property defect repair if another party is responsible. He'll unpack that a little bit further. And the memorandum, which exists at present, was introduced by the Land Property Institute about 2 years ago. And it's now been enshrined in the Act, where a memorandum can be attached to the bylaws which specifies what is Owners Corporation's repair and maintenance responsibility, what's common property and what's lot owner responsibility. We've always had some concerns, and I think the legal fraternities shared that to an extent, because it's a one-size-fits-all solution that is not necessarily going to work with every building, and it doesn't have full account of some of the unique circumstances of your building, i.e. if it's registered prior to 1974, you can't impose some of those particular restrictions. It doesn't necessarily have regard for special bylaws and things that have occurred. So I'd tread carefully a little bit there, and if you do adopt a common property memorandum, it should be done in conjunction with a specialised brief to a lawyer around how it actually fits in for your building.
Thank you. This is where I found it quite interesting. So the current Act, basically, none of these things are permissible under the current Act without the Owners Corporation's permission, but I can guarantee you, as you would know, it happens day in and day out. So cosmetic works, it's clarified within the new legislation that cosmetic works no longer require approval from the Owners Corporation, and they include the standard things as you expect, like hanging pictures, painting, laying carpet, putting in built-in wardrobes. So some of you may be surprised that under the current Act, you are actually not permitted to do that without resolution by the Owners Corporation, because you are actually attaching to common property. Likewise, minor renovations are clarified within the new legislation, and these must be approved by an ordinary resolution at a general meeting of the Owners Corporation. I'm sure many of you have renovated your kitchens over the years and have not bothered to seek permission from the Owners Corporation. We come across this day in, day out as strata managers. Simple things like changing recessed light fittings will also require a resolution by the Owners Corporation. Many times we do see timber floors coming through, and reconfiguration of internal walls actually, but wiring, cabling, putting in access points, that all needs to go through an ordinary resolution. And continuing, renovations to common properties still require a special resolution by the Owners Corporation.
We've got a question, but we'll come back to it during the panel. Just on that, I think there are three intelligent ways of trying to break up different authorities. However, there's obviously limitations to the way that's interpreted. I believe the general resolution can't be unreasonably withheld, but what it doesn't contemplate is how much some of those works do impact on common property, and that's very unique depending on the particular building. Bylaws have been revamped. As you know, there's been a lot of talk in the media about the introduction of new bylaws, the empowerment of pets, how we deal with smoke, how we deal with occupancy. They've all been included in the model bylaws. So for those that have a building that was registered prior to the 1996 Act, so any building built, I think, is prior to 1997, I think the way it works, you will have, unless you have a set of bespoke bylaws or special bylaws, you will have now the new model bylaws to be adopted for your scheme. Those buildings post-1997 will have whatever bylaws were registered at the time of registration, plus any new bylaws or special bylaws you would have put in place. And any new buildings that get registered from the date of the new legislation onwards will have the model bylaws or whatever set the developer actually sets uniquely for that particular building. Within 6 months of the commencement of the new legislation, every building must have a resolution to have considered the bylaws for your building. Doesn't mean you need to change them, but you must consider them. So what the government are trying to do is to promote some more inclusive bylaws, some more modern bylaws, or at the very least a review of your bylaws to make sure you keep contemporary with those. Changes to bylaws have now been limited to 6 months for registration. So the current Act calls up 2 years, I think, which is a rather generous time period for that registration to occur. This means that if that registration has not occurred within 6 months, that's a null and void bylaw. It's not registered on your lot, so therefore there's going to be increased urgency around the way those bylaws are done. A consolidated copy of the bylaws must be kept. We already do that for you on your behalf, so if anyone needs a copy of consolidated bylaws, simply contact our office. We already do that for all the model bylaws, any special bylaws, and we put them in Word format because we know that people like to use them. We use them ourselves with notices and agendas and the like. However, you can use them yourself if you'd like to use a bit of a review of them. And common property bylaws require the consent from all parties gaining special privilege, as is the case now.
Thanks, Chris. I really wanted to talk about this one.
Oh, you can.
I just found this one fascinating because occupancy limits was such a critical thing during the discussion phase of the papers surrounding this, and I do a lot of work with the City of Sydney, and this always comes up in our presentations because they have a lot of uni students and the like in the premises around the inner city and around universities as well. So they originally brought in the restriction that you could limit the number of occupants to a lot, but that could not be restricted to less than 2 adults per bedroom. Once the draft legislation went out, Fair Trading was hit with an uproar about this particular potential bylaw. And they've now added to the final regulations a whole lot of exemptions. So basically, this bylaw would really only apply to premises where you've got a lot of uni students or backpackers, and if there's planning regulations in place around that. So as you'll see up there, I'm not going to go through it, but there are so many exemptions. If you're a carer of the spouse of a carer or a grandchild of the carer of the guardian of the spouse, it's incredible. So you've got to be able to prove that there is no relationship. And as you can see, there's lots of options there for you.
And that could be a bit of a minefield because proving up some of those connections don't exist is going to be challenging.
Thank you.
Now the general interest items. Now we've condensed quite a few what we think are big ticket items into these. We're happy to actually talk about them in the Q&A session, and we're likely to have some special interest seminars on these because some of these are incredibly relevant to some buildings but completely disinteresting to everyone else. So I'm going to go through a few of these. This is where I think some of the real meat is in the new Act. A lot of them are around defects and collective sale, but I'll come back to those. So a special resolution to create a strata parking area essentially allows council to treat that particular area of common property as if it were council's property, and therefore they can enter those premises and fine as pursuant to Local Government Act. So you need to pass a resolution to do so. I suspect many buildings that have been dealing with those particular parking issues, particularly community or strata plans within communities or those with large areas of common property, will find this a very interesting adoption. Process for the disposal of abandoned goods. So this applies to all abandoned goods except vehicles. So you can imagine someone dumps items in the common property, someone leaves a bicycle in the hall. You now have the authority, subject to certain notices and time periods, to dispose of that and potentially keep the money. So there is a process that's going to be played out there, and obviously we need to make sure that there is an equity argument applied to how that is done. Vehicles have their own minor change. You can move a vehicle if it is on part of common property and blocks access or safe egress and the like on common property. It hasn't touched on the perennial issue of if someone is parking in your private lot owner property, what you can do about it. So that is a different issue in itself, and again, the lawyers can talk about the property right issue around trespass.
Or abusing visitor parking either.
Or abusing visitor parking, correct, because technically that's not in an egress path, although I'm sure the smart people around here will make it very likely that the way through the visitor parking is to an egress parking and you can move that car. Building defects, again, to unpack this right now is very challenging. This applies to new buildings. There is a whole swathe of introduction of new mechanisms around a building bond for new schemes, which is a 2% bond of the construction contract that is held in escrow effectively by the state government and is only released after certain reports have done and after certain defects have been remedied. There is the obligation that we talked about that statutory warranty defects need to be addressed on every annual general meeting. There is obligation for certain reports to be done and with which time they're to be done. There is obligations on initial maintenance schedules, which is for new buildings the developer hands across prior to the AGM a full suite of maintenance manuals, including a prescriptive way of maintaining the common property, which they can hold you somewhat accountable for into the future if you don't comply with them. Again, I know we've got some experts here, particularly on building defects, so happy to ask our lawyers when they come up, but we will be holding a separate seminar on this because its relevance is only to new schemes. The collective sale likewise received a huge amount of media attention, so this is the 75% rule. So at the moment, under the current Act, you need 100% of lot owners to consent to the sale or wind up of a strata scheme. Obviously, the introduction of what they call the collective sale and renewal process or the collective sale and termination process is to try and limit the holdout that they thought was precluding some buildings from being able to be developed. So it's now 75%. There is a significant process in the strata schemes development that will be introduced. It may be of interest to some of you. If it is, please take it offline because we're working with some buildings at present who want to investigate this particular option. One thing it has done is it's promoted discussion for those buildings that want to terminate or want to redevelop or want to renew their property. There are completely legitimate circumstances around the inhibitive cost of maintenance as well as the potential development side that make this a somewhat sensible clause, but there's also a very broad equity argument around people and enshrined property rights. So the process that will be introduced is rather robust. Again, I just wanted to touch on it. Introduction of alternative dispute resolution. So the Act implies that we can now have the Secretary effectively conduct dispute resolution processes that you can have within your own owners corporation. They're non-binding, but they're going to seek to try and flesh out some of the disputes before they hit a tribunal. So again, it's trying to make sure that we can collaborate a little bit more to deal with disputes prior to going to courts and tribunals and the costs associated with that. And finally, on insurance, touching on the requirement for the mandatory disclosure of commissions, strata managing agents will have to provide you with 3 quotes prior to renewal, and if those 3 quotes can't be sought, we'll have to give you an explanation in writing as to why 3 quotes can't be provided. We already provide multiple quotes for most, if not all, schemes. We don't see this as being a big problem. This will be a problem for a lot of other managers who have a single quote policy and don't have an insurance department. We set that as being just good practice in the marketplace, and there's the introduction of a number of new direct retail of insurance as a direct result of this particular motion.
Chris, so this is our opportunity to share with you the way we're implementing these changes within our business. There's a lot of changes that we have to undertake, and unfortunately we have a very, very short time frame to do that. So just to give you an overview, we've employed a full-time project manager, Belinda, she's here in the room, and she has the responsibility for chairing the steering committee with relation to this project. We've appointed subject matter experts across our business, particularly amongst our senior management team. In such a short period of time, it's very difficult for all of us to become very familiar with all the specific details of this Act. So we've appointed those subject matter experts to focus on those particular areas and then share that education with the rest of our employees. And as part of all of this process, we're undertaking a business process re-engineering project. So we're identifying all those areas that the Act will force us to change our business process to meet these requirements. As a result of that, there is a lot of documentation that we need to change. Even though we are moving down the path of electronic distribution, there's lots of changes to the templates that you currently see with regards to AGM minutes, notices of agenda. There's standard motions that we need to have drafted now to include on those. There's a lot of different forms. The proxy forms changed. Some of the previous section 118 forms have changed. Our section 109 is now section 184, and that's changed. So again, procedures, we're documenting those, documenting work instructions for our staff, and we're creating a range of quick reference guides that will be useful for both our staff internally and also our clients. Most importantly is the training, once we've got that all bedded down, and this is the start of that training here tonight, but we've got two obligations here. We obviously have an extreme amount of internal training that we need to do for our internal stakeholders, and that doesn't just mean our strata managers. There is a whole range of people in the back office at Bright&Duggan that are responsible for answering your calls and inquiries, and we need to train those people up to speed as well. And importantly as well is the education of our external stakeholders. So that's not just yourselves here in this room or the wider owners corporation community, but we also need to look at training our contractors. We need to look at training people like property management agents. And technology. So we have a very strong partnership with one of the leading strata management software providers in Australia, and that's StrataMax. We've already commenced negotiations and workshops with them about how technically we need to apply some of these changes within our business. And as a result of that, we have to invest in infrastructure to meet those requirements. So we're committed to making sure that we can give you the best opportunities to meet the technical requirements of this change. We've also have to introduce a records management system. So we are looking at bringing all of our documentation to be available online. We're in the process of that project at the moment. We're working with Fuji Xerox on that. And having that accessible to you 24/7. As part of that records management suite, we've also just recently completed a data cleanse of our entire strata roles. So some of you will have already started receiving your email notice, levy notices via email. That will be distributed out through all of our buildings over the coming weeks.
Thank you to Melissa and Chris for a really whirlwind presentation, full of information and extremely interesting. I think in my mind, I haven't read the full act, I won't say that, but I have browsed through it and it raised a lot of questions, and I think it prepares us well for the Q&A session, which we'll now move to. I would like to invite to the stage now Scott Chambers and Daniel Russell. Both Scott and Daniel are partners at our collaborative legal firm, Chambers Russell. Now, I'm going to have to read this because I don't know all about his background, but Scott is deemed to be an expert in commercial litigation with experience in the Court of Appeal, Supreme Court, District Court, Local Court, and the New South Wales Civil Administration Tribunal. Scott is active in the resolution of disputes, including in the construction industry, tribunal claims, and strata disputes. Daniel is an industry expert in the field of strata and community title law. Daniel is an experienced litigator in a number of areas, including strata disputes and commercial arbitration. Could I please invite both Daniel and Scott to join us? Just a point, I think Chris touched on this earlier. If you'd like to get more details of the resume of the four people here, it will be on our website by about mid-next week as part of the presentation that we have. We have two mobile mics. Yes, we are in place. Good, excellent. From a housekeeping perspective, I would ask that if you have a question, please raise your hand. I will then identify you and you can move down to one of the roving mics. Please bear in mind that the questions this evening are limited to those relating to the new Act and not of a more general nature, which can be taken offline. Questions can be directed at individual people if you wish, or alternatively, you can put it to the panel and they can fight over who's going to answer the question. May I now invite the audience to please put their questions to the panel. Yes, please.
It sounds like quite a revolution in having tenants attending the AGMs. I've got lots of questions about that, and I don't, from what I picked up in the presentation, it sounds like, well, you must have a tenant there. I'm not sure whether tenants must be there as a proxy or they can come anyway. I'm not sure whether they can put agenda items on the agenda, and I understand that they can't vote, but they can speak after a resolution has been passed. So does that mean they can't say anything until after something's been passed and then they can say, I don't like that? What do we do with that? And do you have any insight into the thinking behind this change and what risk management or governance we should put in or be thinking about in terms of inviting, speaking as someone who does have more than 50% of tenants in the building?
Thanks, Fiona.
So I think the Tenants Representative Union had quite a lot of say in this part of the Act. It's similar in a way to how lot owners who aren't executive committee members can attend executive committee meetings and can't address the meeting unless there's been a resolution by the executive committee members. So they've kind of replicated that similar procedure. There's a lot of, to be perfectly honest, my personal opinion is that tenants had just as much flexibility and availability to participate in an owners' corporation. All they needed to do was get a proxy from their lot owner, and they actually had just as much voting rights as the lot owner does. So I think this has been included to settle down the Tenants Representative Union, in all honesty. From a lot owner perspective, I'm particularly glad that we were able to convince them that we didn't have to formally advise in writing, because that would have been an added expense to the owners' corporation. So I do really think this was a political intervention on that part.
Fiona, I'm sure that Melissa will be more than happy to give you detailed answers to the other bits and pieces that I also was quite intrigued with as to why they can sort of speak after a resolution. It interests me. Yes, sir. Sorry, no, I'm
Two.
It won't be long.
Sorry. Just to clarify, I think the resolution that you're talking about is to allow the tenant it's not that they get to speak after any resolution. It's that there's a resolution that allows them to speak. So that's the terms of the resolution that allows them to speak.
And you can have that resolution at any meeting, or it can be a standing resolution.
Yeah, so my actual question was, I thought that the review process of the bylaws was 12 months after they came into effect, but you've said 6 months tonight?
6 months for registration, I believe.
Yeah, 6 months registration, but the review is 12 months.
12 months,
sorry.
okay.
That was my fault. I gave Chris the wrong.
Exactly.
Gentlemen in the front here.
Yeah, I just had a quick follow-up about the tenant thing. Is there a separate tenant meeting?
Yes.
So is that not going to be another cost, or how's that? What is that?
It's an excellent question, because there's nowhere does it say who has to chair that particular meeting, who's responsible for the governance around how that occurs. As I mentioned, the 14-day requirement, which is in excess of the need for obviously notification of a general meeting, may well throw up issues around legality of the meeting process. How they're conducted, who pays for it, how it's nominated through, whether it's conducted correctly. These things need to be panned out. Ultimately, someone will need to attend, facilitate, moderate, collect all the votes if that's necessary, and then, as Melissa talked about, if there is a vacancy, that needs to be filled immediately.
There's representatives at the tenants meeting?
No, they're not.
Right.
No,
I actually had my original question, which I was going to ask, it related to, I saw a thing up there, you said it had about things where you need an ordinary resolution to put them, one of the examples of floors and all that kind of, was it minor renovations or something like that?
Cosmetic, minor and major.
Yeah, so it wasn't the cosmetic, it was the minor. And the example there was floors, and it said you needed an ordinary resolution of the owners' corporation. Now, ordinarily that's just, is that the same as the the Strata Committee approving that? Or so does that mean anyone who wants to, say, put in floors or change their floor treatment, that has to go to a whole owners corporation meeting now? Or is
I assume it's simply as it currently stands, and correct me if I'm wrong, Scott and Daniel, but if there's already a bylaw in place that addresses the fact of the installation of timber flooring, then that can be approved by the Strata Committee. But if there's no bylaw in place, then it would need to go to ordinary resolution.
So
Ben?
sorry. I apologise for jumping in. There's the minor renovations power also contains a power for the owners corporation to make a bylaw empowering itself to delegate its own functions to the Strata Committee. So for all those species of minor renovations in there, which includes the flooring and if you look at the regulations now, there's split system air conditioners and all kinds of other things which can be fairly serious. There can be a bylaw made which will allow the owners corporation to delegate those functions to the committee. But if you look at I apologise if I'm going to run on here, this stuff's really interesting to me because there's been a history of trying to make renovation works simpler to deal with in Strata going back a very long time, starting with the basic assumption that we needed to have bylaws in place. Last time around, in about 2005, the government had a go at creating a couple of sections. 65 capital A was an example, an attempt to simplify things by allowing, instead of a bylaw, a special resolution would be sufficient. But the caveat with that was that if, and still is at the moment until 30th of November, if the obligation to repair and maintain the renovations, affected common property, I should say, was to be passed on to the lot owner, the owners corporation had to make a bylaw with the consent of the lot owner, which meant effectively we're back in the bylaw space again. What they've done this time is complexify things threefold. So we have that regime. The 65A is now section 108. We have cosmetic renovations under section 109, which don't require any approval. We have these minor renovations under section 110, which require a general meeting approval, or if possible, if it has been delegated, then the Strata Committee can do it. But in all of these circumstances, the obligation to repair and maintain the renovations doesn't pass to the lot owner. We're back to a bylaw if we want it to pass to the lot owner. And there's some other fairly significant problems with the exclusions from these different categories of work. So cosmetic renovations and minor renovations both exclude obviously structural works. They exclude waterproofing works. They also exclude anything which requires approval under any other legislation. Now, if you look at the environmental planning legislation, which comes in great big wads, there's an awful lot of renovation work which requires some level of approval there. And there's actually directly conflicting examples like the split system air conditioning. Well, in most cases in a strata scheme, you can't do that without some kind of further approval, installation of awnings, or changing the internal configuration of a room, for example, is again, the legislation nominates it here as a minor renovation, but it then excludes it because you need to get development consent for it. So,
Daniel, I'm sorry to interrupt.
No, sorry.
I just wonder whether you mightn't take it up directly, because I know there are some other questions on, and maybe we should move. Yes, please. Ben, thank you.
I'd like to just go back one step. A registered tenant is a registered tenant with that particular owners corporation, or is it just that they've actually paid their rates at the...
Tenant is in relation to them being registered on the strata roll for that particular lot. So, as I was saying, the managing agent, property managing agent, or the lot owner who is renting that property out must advise through whatever section it now is, advise the strata managing agent or the secretary of the terms of that lease and the name of the people within that lease. And then we're required to enter that on the strata roll and then to use that to calculate the 50% threshold.
Thank you. Yes, please.
Thanks. Regarding proxies, I understand the one per person or 5% if it's over 20 lots. Is the strata manager entitled to as many proxies as people want to submit?
The proxy provision, it refers to a person and not an owner. So, no.
No, we, as managing agents, we'll have the same limitation with regard to receipt of proxies as any other owner.
Hello. So, for example, you know, if you had 30 lots, for all intents and purposes, and a very inactive group of owners, you could technically only, you know, and people gave 2 proxies. That's it.
Yeah.
Right. Okay.
Notwithstanding that, you would need a quorum based on the 30-minute threshold where you could pass resolutions based on that limited proxy.
Right. And that's for all meetings, for annual general meetings.
General meetings.
Annual meetings and
Correct.
and general meetings.
Yeah, annual and extraordinary general meetings.
Right.
I think the proxy provisions are, as Mel has mentioned, they're there to prevent the tyrant that goes and collects 50 proxies. But it's still the case that if people act in concert, that they still might end up getting 50 proxies within their camp of 10 people, for instance. So I think it's a great step towards ensuring that that individuals don't wield as much power, if that's a good thing. From one perspective, it might be, might not be from another. But I don't think it'll completely stamp out the practice.
Thank you. Ben?
Does the new Act shed any light on the rather challenging issue of short-term and holiday rental?
It does. Sorry, the questioner put his hand up. I'm having difficulty seeing in the lights.
Over there.
Okay, great. So, look, it does, but it doesn't at the same time. The most important thing I think that anyone can take away any discussion about short-term letting and associated problems is it's not really a strata law issue. It's really a planning law issue. So you can get lost looking at the strata legislation and the bylaws and all of that kind of stuff, but the one thing you really should be looking at is the Environmental Planning and Assessment Act, which says that the planning instruments take precedence. And they take precedence over covenants, they take precedence over easements, and they take precedence over bylaws as well. So if someone has approval under a planning instrument to carry out short-term letting, then that's it. It doesn't matter what your bylaws say about it. That's the current status of the law, and it will continue to be the status of the law. What your bylaws can say, and it's been in the standard bylaws for some time now, they can say that you can't conduct something which is in conflict with the planning legislation. You can go beyond that and say, look, you need to have, tenants need to be on residential tenancy agreements, they need to be of at least 90 days duration, but at the end of the day, anything else you add is just going to be struck down by the planning law and the planning instruments. So what really needs to be done is some legwork around what the applicable planning controls are in your particular strata scheme. The good news, if you're a person who's against short-term letting, is that it's really not very commonly allowed. People think it's more commonly approved than it is. There's only a very few sort of enclaves in Sydney where it's actually a permitted use at all. And in most circumstances, it does require development consent. And in most circumstances where people are doing it, they don't have development consent. And then if they were ever ingenious enough to go and try and get it, they discovered that the local council would ask them for a $35,000 development contribution, which is probably not in line with the business model of the person that puts up their apartment on Airbnb. So, as I say, it's not really a strata issue. The law is basically going to be the same as it previously has.
Thanks, Daniel. Thank you.
I have a question about the new 75% rule. Is it based on entitlement or lot number?
Oh, the strata renewal. So the direct answer is it's based on lots. The long answer I'm not going to give you because it's a very, very detailed process. But there's a lot of different thresholds in that process. But the one you're referring to is the ultimate adoption threshold, and that is 75% of lots.
Thanks, Daniel. Look, we've got some time. Yes, sorry. Thank you.
My question relates to executive committee meetings. General meetings have to have motions. Executive committee meetings that are going to be held by teleconference, video conference, email, etc., only need to be detailed. What does detailed mean, please?
Well, it's kind of subjective, I suppose. And again, it will take some precedence to mark that. But I think the intent of that part of the legislation is to enforce enough transparency around the notice of agenda that lot owners who are not on the strata committee have enough information to determine whether they would like to attend the meeting and hear the discussion that is to take place. So it's not a matter of, I strongly discourage in any of my workings with strata committees the term general business, because it does not allow for transparency for those lot owners who cannot attend. So it's about a reasonableness around that.
I think it's worth adding as well. Melissa's quite right. The core of it is people who are not on the committee should know what the committee is doing and be able to decide whether they attend. But there's another limb to it as well, which is that 30% of the unit entitlements can actually veto an action of the executive committee, but they have to do it before the meeting. So we think the best legal interpretation of that is that the agenda must be clear enough to indicate what decisions the executive's going to make so that they can be vetoed by the rest of the owners.
Time is beating us. I think we've got time for 2 more questions.
Okay, thank you. Look, I have two-part question. It's relating to tenants. What protection do owners have, for example, from tenants 1, when they go on holidays, they rent their place on Airbnb and people change daily? And the other one is when they rent a place, hold the lease, and then they have groups of people that turn over regularly, plus they have a huge amount of people turning around in that unit. What protection do we have?
Can we have a pretty quick
Yeah,
reply?
a quick answer. Look, I think Daniel's explained the situation with the planning law and the fact that an appropriate worded bylaw in most circumstances, in many of your strata schemes, will be able to regulate short-term letting. One of the background to the enforcement provision, which we haven't really touched on, is that there are now increased penalties for owners, and I know that you're talking about the tenant, but there are increased penalties for owners that don't comply with bylaws, and if they don't comply within a 12-month period, then those maximum penalties double. So they go up to $2,200 for every subsequent breach of the bylaw. And if you breach the occupancy limit bylaw, then it can be substantially higher. I think at the top end, $22,000.
Thank you.
Limit bylaw is a standard one, or we have to make one in the building?
So it's part of it needs to be adopted, yeah.
Okay, we have time for one last question. If in fact we have one last question. Oh, here we This lady up the back first, please.
Can you guys expand a bit more on the capital works venture, what we have to do with regards to the plan and how binding it's going to be?
You've got 30 seconds to answer it. Who would like to try?
I think the short answer is more binding.
More
Yeah,
binding.
yeah. There's more that you need to do. Owners Corporation must use their best efforts to comply with the capital works program. You need to budget. You need to set out in the plan exactly where the source of funding is going to come, and you need to document at every AGM exactly where you've gotten to and give reasons for why you have or haven't spent money in accordance with the plan.
So specifically what you said is not correct. There are a few things which kind of feel like that. One of them is at every general meeting, a large strata scheme has to explain why it's not meeting its sinking fund or capital works fund targets. And another one is that the developer of a scheme, and this is really exclusively for new schemes, the owners corporation can claim against the developer if effectively the levies were set too low to begin with and subsequently have to be increased.
Thank you. Look, regrettably, ladies and gentlemen, that brings us to the end of the Q&A session in terms of in here. On behalf of Bright&Duggan and Chambers Russell, I'd like to very much thank you for your contribution and your participation. As we said at the beginning and mentioned a few times on the way through, this is an extremely interesting period of time we're going through, and we truly are moving through uncharted waters. All stakeholders, and that goes owners, tenants, we talked about, strata managers, legal advisors, developers, government agencies, we're all going through a very steep learning curve with the new Act, and I think we're going to really find it very interesting and challenging. I hope you've found that this evening has given you some insight. There are a couple of insight into the new Act. There are a couple of points I'd just like to make because I know we already have been delayed because of the late start. When we're finished here in a few minutes, we'll be moving out to the foyer for light refreshments and drinks. We've got something like 30 Bright&Duggan staff here and a number from Chambers Russell. Please seek them out. There are clearly a couple of unanswered questions and even looking for more details on questions that were addressed. Please seek out the staff. They're there. They're very keen to speak to you. If they can answer your questions, they will. And if they can't, they most assuredly will take some details, make some investigations and get back to you. Okay, yeah, well, there's been an offer that at least one side of the forum is prepared to wait around and take some more questions, but I'm sure that it'll be counted by my friends on the right. As I said, Chambers Russell have also got a number of people out there, so do please take advantage of them and their knowledge. Before we move outside, a little bit of housekeeping to wrap it up. We're nearly there. Could you please spend a minute or two looking at that questionnaire and complete it for us? And if you would be so kind as to leave it in, there's some boxes at the back on the way out. We'd very much appreciate it. When you leave, may I encourage you to take a copy of, we've got a fact sheet. You'll find it's a bit of a summary. I think you'll find it most useful. I would encourage you very much to take that with you. Finally, tonight's program has been podcast and will be available on the Bright&Duggan website by mid next week. So if you want to re-look at some of the answers or some of the issues that were raised, you'll get the opportunity. A final point, if I may. An evening such as this doesn't happen without a tremendous amount of work and organisation by people. It would be totally remiss of me if I didn't acknowledge the work of one of my colleagues, Bill Irwin, who has put in an enormous amount of time in arranging the invitations, the program, the running order and everything else. And to Bill, you've done an absolutely first-class job. Thank you, ladies and gentlemen. This concludes this part of the evening. Please feel free to come out to move outside or talk to the panel. Have something to drink and something to eat, and we'd be delighted to have further discussions.